Hi, Andrew Rodenhouse here. Welcome back. So I want to talk a little bit about why somebody would want to run their preliminary exam versus why they would want to waive their preliminary exam. Oftentimes in Michigan, the county prosecutors got a lot of cases, the court has a lot of cases, and so oftentimes they will make an offer to waive the preliminary exam. And by waiving it, all you're agreeing to do is that you just agree that you're going to go forward into circuit court, that there is probable cause, but you're not agreeing that you're guilty of anything. In fact, at the time that if you waive your preliminary exam, at that exact same time you enter a waiver of arraignment in circuit court and enter a not guilty plea. And so you preserve all your trial rights. You still have all your trial rights. But the question is like, when should we do those things? Why should we do those things? What's the strategy behind that? So I want to talk to you about the strategy behind it. I oftentimes hear from potential clients or clients that have come on from other attorneys that they were pressured one way or the other. And for one thing, I will never pressure a client to do one thing or the other. I will just give them my advice and they're free to do whatever it is that they wish to do. However, if you're not listening to my advice, then I can't help you when the outcome is bad. That's just what happens when you don't listen to good advice. At a preliminary exam, there's going to be testimony taken, and that testimony, if a witness, so for example, if a witness later decides to recant or that witness is no longer available to testify, then their testimony at the preliminary exam have been preserved and will be used at the trial as if they were there testifying in person. And I've had multiple times where it's particularly true in domestic violence cases or in rape cases or even sometimes drug cases or armed robbery cases where the alleged victim is a drug addict. And that person shows up and they testify at the preliminary exam and they are just not believable. Just due to their mannerisms, their eyes are glassy and bloodshot. They don't look good. A jury probably wouldn't believe them. But then all of a sudden they go missing. Oftentimes these people are transient, or I've had cases where they've just overdosed and died and they're not available. And at that point in time, what happens is that transcript from that hearing comes out, and what you end up with is a very attractive law student from the local prosecutor's office reading that transcript as if they were the person testifying. And the jury doesn't then get to see their bloodshot eyes, the tattoo on their neck, their caginess, their fidgeting, the fact that they're under the influence or they're recently withdrawing from whatever it is that they're on. And so that's one reason why I would waive, and I've actually waived cases for no offers just to keep the person off the witness stand, because I know that there's probably going to be a later date where they're not going to be available, and then the prosecution can't proceed because there's no transcript from the preliminary exam. It happens a lot in domestic violence cases. Suffice it to say that, let's say a couple, they're arguing and they end up in a fight. One of them gets charged with domestic violence. They hate each other. But if you run your preliminary exam, that testimony is preserved. And what oftentimes happens in domestic violence cases is that they reconcile. And they want to get back together. A lot of times they have children in common and they need to work things out just simply because they have to have a relationship with each other, even if they don't want to. And that domestic violence charge, by having that transcript there, that person can't change their testimony, or that person is locked into it. And so what can happen is you end up in a situation where you can't have that person take the stand and testify different to that, because then they would be committing perjury. That would be provable. And so I, generally speaking, advise people to waive in those circumstances. There are times when it's a good idea to run a preliminary exam, especially if the alleged offense doesn't match the crime. I had a young man once who was charged with a home invasion. I think it was in the second degree, And what he did was he broke into his dad's house and stole an Xbox. It turns out it was his Xbox that dad had given to him as a gift, but it was kept at dad's house. And he stayed with dad occasionally. There was a visitation schedule. And we ran a preliminary exam, and the judge agreed with me that, yeah, you can't break into your own home. It's his home. Even though he doesn't live there full time with dad, it's still technically his home. And so therefore there was no home invasion. It might be a different crime. It might be malicious destruction of property, pay for the window kind of situation, but it wasn't a home invasion and it wasn't a felony. I've had other times where I think it's important to understand that oftentimes if you don't waive your preliminary exam, let's say they give you a decent offer and it's an offer that maybe you don't like it right now, but it's not going to get any worse going forward if you waive, but sometimes it'll get a lot worse if you run. I mean, I've had cases where I've advised I had one case just this past year where a young man was charged with stealing receiving and concealing a motor vehicle. They had offered him a reduced misdemeanor, and he insisted on running, and then it got bound over on 2 counts of carjacking, a life offense. And so that was a case where really he's made some really bad decisions for himself that put himself really behind the 8 ball going forward in his life. Some other reasons why people might want to run or waive is if it's a family matter, if it's an internal family matter, or it's embarrassing and the media is involved. I've had cases where that's true, and that the facts, if we would run the preliminary exam, would reveal facts that are just really embarrassing for the person who is charged. And so again, it's all going to come down. Every case is unique. Every case is different. Every client's different, and so there's a lot of different reasons to do it, to run or to waive. Oftentimes I think that people come into it and they're like, well, I'm just going to fight everything and we're not waiving anything. And it's like, yeah, but you're really starting out behind the 8 ball sometimes if you do that. Other times people are saying, like, I just don't care, I just want this over with. And I'm saying, well, look, you got to push back a little bit, and maybe this would be a good time. Maybe we can get something reduced. And they're not willing to do that. But overall, I try to look at every case individually, make the best course of action for that case. And so there are a lot of different reasons for people to do what they do. I would say more than likely, 90% of the time, I advise people to waive because we're getting something that's advantageous. But anyways, every case is different. I hope I can help you if you are watching this video. I hope you found this educational. And with that, have a great day.